Morning, and to those of you in California, good evening, because it's still last night, as far as I'm concerned. This is Mesmer Ticklewickle, and I'm here with Christopher Denicolo and Brandon Ketron, and I'm going to show you a video that I'm very sort of proud of, and this was from the Broadway show, Pension, Oh Pension. So we hope you enjoy the video, and then things will get better, and we'll actually get to the matter at hand.
A long, long time ago, when we could use a see-through trust for lifetime payments with great pride. And I knew that if I had my chance, that I could make beneficiaries dance and even be happy when their grandpa died. But the Secure Act made me shiver with the bad news it delivered. A 10-year payout required. I will be less admired. I can't remember if I cried when Natalie's book no longer applied, but something touched me deep inside the day the less than rapidly rule may have died. So bye-bye life expectancy sigh. The passing of the Secure Act left folks high and dry. Trust drafters all over drinking whiskey and rye, saying the at least as rapidly rule may not apply. The at least as rapidly rule may not apply. Do you know about our tax code and how all the laws have ebbed and flowed? If your advisor tells you so. While certain things might become wild, a trust will better protect your child, so they will have heat when there is snow. And I knew that IRAs had changed because my parents needed things arranged, but there's no need to sing the blues because neither have reached age 72. I can't remember if I cried when I read about example 5. Will the as least as rapidly rule survive when the life expectancy rule died? And so I'm singing bye-bye life expectancy sigh. Drove my Chevy Volt to the levee before the battery died. Those poor old tax lawyers were drinking whiskey and rye, singing today the life expectancy rule died. Today the life expectancy rule died. But I surely did not expect to see my Chevy crashed by 401A9B. We both had taken off our shoes, and I had my conduit trust ready to use. I knew that a couple we would be. I had fantasized about our RBD, but marriage would be required before that would be the day the stretch rules died. And now I'm singing bye-bye life expectancy sigh. I am lucky the Secure Act lets Teapot.
All systems ready to go. 5, 4, 3, 2, 1. Okay, good morning, everybody. I'm Alan Gassman. I'm here with my partners, Christopher Denicolo and Brandon Ketron, and there is nothing we would rather do on a Saturday morning than review new proposed Treasury regulations on IRS IRA trust rules. We thank the IRS for 265 pages of pleasurable reading, and we thank the law clerks who work for our law firm for explaining what these regulations mean. So Chris, Brandon, welcome. Brandon, this is what it's like to be awake at 9 o'clock in the morning on a Saturday. As a new father, you probably figured that out fairly recently.
Yeah, I've been well awake. 6:30 this morning, so.
Yeah, it's even light in the morning at 9 o'clock when you wake up. Okay, this presentation does not qualify for continuing education credit, primarily because it's not good enough. And remember, 3 to 5 hours after the webinar, you will receive an email with the recording of this webinar, which you can watch as many times as you like. And you will also be receiving the PowerPoint materials. If you want to ask a question, that's fantastic. Just click on the question inverted pyramid, type in your question, and we'll probably ignore it, but you could still ask it anyway. We have a Saturday at 11 webinar coming up at 11 o'clock today on section 199A, but then please do tune in to Jerry Hesh and I will be talking about innovative charitable planning on Saturday, March the 12th, which gives you a reason to live until Saturday, March the 12th. So a lot of propaganda here and a lot of interesting stuff, but I want to start, Brandon, if you want to take us through the key takeaways from these new proposed regulations, a very brief pre-review of what we're going to talk about for the next 30 minutes.
Yeah. So number one, we just wanted to point out these are very long, as Alan said, 265 pages. So we're still reading through these, still trying to understand them, but we're going to do the best we can with what we know today. Number two here, this is probably the most interesting aspect of these proposed regulations and the one that would impact the most people. We don't know if this is correct according to the statute. It seems to be a little bit of a stretch that the Treasury has taken here, but essentially what it says is if you have an IRA owner that's died after their required beginning date, which is 72, meaning they're taking required minimum distributions each year, and then they pass away, leaving it to one of the non-eligible designated beneficiaries, meaning not a spouse, not a minor child, not a disabled or chronically ill individual, or someone who is less than 10 years younger than them. If they leave it just to their adult child, then what happens is, under the Secure Act, we thought that the 10-year rule would apply, that all assets had to come out of that IRA by the end of the 10th year. We didn't think anything would have to come out in years 1 through 9. You could completely defer it to the end of the 10th year and then make a distribution by December 31st of that year. Well, what the proposed regs have told us is that that's not the case. You actually have to go back to the old rules, determine the oldest designated beneficiary of a trust, or determine the life expectancy of that adult child that you've named, take distributions in years 1 through 9 based upon that life expectancy, and then if there's anything left at year 10, that all comes out. Who knows if that's going to make it to the final regs? There's been a lot of commentators say that that's not what the statute says, so we'll just have to wait and see how this all turns out. The issue, though, is if you had someone that died in 2020, you got relief from the RMD in 2020 because of the coronavirus rules, but in 2021, now technically you might have had to make an RMD distribution under these proposed regulations, and the penalties are severe. I mean, it's 50% of RMDs that weren't distributed. Now, presumably we'd have some sort of reasonable cause exception that would apply if this does make it to final regs to save us from those penalties. But as far as planning goes, you might just want to keep in mind that if these do make it to final regs, that you may have to make up some RMDs there very quickly if you're relying on the 10-year rule. So Chris or Alan, any other comments on that?
Does this apply if it's payable to a trust that qualifies for a 10-year
Yes.
stretch?
Yes.
Okay.
Yeah,
one comment is these are proposed regulations, which are not necessarily law at this point, but could ultimately become law in final regulations. So it certainly remains to be seen whether final regulations will A, have this provision in there, and B, have a retroactive effect, as Brandon mentioned, where you would have to make 2021 required minimum distributions.
Yeah, it'll be interesting to see how this works out. Michael Kitces, Kitces, has a really good write-up on this, including, which we'll discuss later, that the IRS at one point said that this would not be their position. But what really made me happy in these new regulations is that you can have an IRA payable to a trust for individuals and get this 10-year stretch, even if later on creditors or a charity or older people who would not otherwise qualify for the stretch may benefit. And that's number 3 here. And we're going to talk about more about that. And they made it confusing, probably for no reason, because it has to be a second tier 2 beneficiary. So the tier 1 beneficiary is your grandchild. And then the tier 2 beneficiary are your great grandchildren. And then after them, after 2 people have died, then the creditors can come in, so you can do your GST planning. Then your charities can come in. So that's number 3 there. Chris, do you want to briefly mention the power of appointment options that we're now going to have as planners under these proposed regulations?
Yeah, Alan. So there's a lot of clarity given as to who counts for required minimum distribution purposes. And what the rules say is that if you have a power of appointment, and if it's exercised before this magical September 30 of the year after the participant dies, we call that the designation date. If the power of appointment is exercised or restricted before then, it's the potential appointees of the power of appointment and the takers in default that would be counted for who are the beneficiaries of the retirement plan. But if the power of appointment is not exercised, it seems that the permissible appointees are not counted. It's just the takers in default, meaning that I set up a trust for my good friend Brandon. I give him a testamentary power of appointment on his death to appoint it to any individual who is younger than him or any charitable organization. If he does not exercise that power of appointment by September 30 of the year following my death, then it seems that the charities aren't taken into account.
That's wonderful.
If for example, it says that on Brandon's, if he doesn't exercise the power of appointment, it just goes to his children. So that gives us some clarity, and maybe that's the chip that the IRS threw on the table to say, well, hold on, now you're going to have to make these stretch payments over 9 years until the 10-year rule. It's certainly taxpayer friendly.
That's nice. And then number 5, the regulations basically speak favorably of anything you have to do before September 30 of the calendar year following death to get that trust fixed. And our documents provide for, we call it qualified plan trust protectors. So even if the client doesn't want trust protectors who can amend any part of the trust, we have a provision that allows them to amend any trust to the extent they deem appropriate to qualify for the stretch rules. And that will be perfectly well accepted under these regulations. So let's all remember that when the IRS comes out with a proposed regulation, a taxpayer can rely upon the regulation, but the IRS can't. So the parts you like about this regulation, I'm very sure that they'll pass. They're not going to go away. And we can start relying on them now. Or at least we can start relying on them after next Thursday when Natalie Choate gives her Lineburn talk. That's the only time that everyone in the United States of America is going to be absolutely sure that we know what the rules are. So if you know Natalie, don't tell her I said that. But we're all waiting for Thursday. We're considering that to be a national holiday at our law firm. All right, so those are the key takeaways. If you're not really interested in this topic, you can just go back to sleep now or whatever you were going to do, or go ahead and start your second Bloody Mary, because we're going to now talk more about the rules in general and how these.
We do have a couple of more key takeaways if you wanted to flip one more slide forward. I think there's 3 more there.
Okay, go ahead, Brandon.
To mention. So just quickly, I'll go through these. The first one, if you have a disabled or chronically ill beneficiary, it's the date of death that's relevant. If they're not disabled or chronically ill as of the death of the IRA plan participant, then they would not qualify. You got to document this as well and submit that documentation to the plan if you want to qualify for the stretch using this exception. Number 7, there's not a whole lot that has changed with respect to a surviving spouse. most circumstances, you're going to want to roll over that IRA unless they are under the age of 59 and a half. In that case, they may want to take as a beneficiary to avoid the excise tax. You can still leave it in trust, but there's going to be restrictions on that for the surviving spouse. We'll go through those in some subsequent slides. And then number 8, if you're familiar with our Teapot trust system, this is still going to be important. You can still use this. There's just a few tweaks that we've had to make to it because of these rules that may require distributions to come out in years 1 through 9. We have to be concerned about not having an older beneficiary there so that payments don't come out quicker in those first 9 years than they otherwise would have. And we'll talk a little bit about that in either this presentation or future slides and for future presentations.
We have a tacky video on Teapot Trust that we'll show at the end for those of you who are strange enough to wait and watch it. Okay, did you want, Chris and Brandon, did you want to cover anything on page 13?
I think it's just worth mentioning that, this is a good slide to show what the Secure Act changed. It's the nuts and bolts here. For those of us who don't have the foundation, this will help us understand some of the terminology. Most important is, the life expectancy rule. We throw that term out there. That's the stretch over life expectancy of a beneficiary. The other term that we often use is eligible designated beneficiary, and that's one of the magic 5, that the spouse, minor child of the participant, not any minor, just the minor child of the participant, a disabled beneficiary, a chronically ill beneficiary, or a beneficiary who's less than 10 years younger than the plan participant. And those are the beneficiaries that are entitled to the stretch under the Secure Act by and large. I think we can move on through the slides, Alan, if we want to even get into the some of the things that have stayed the same from the Secure Act. The proposed regs don't really change much of this. It's surviving spouse, as Brandon pointed out, has options for rolling over or taking as a beneficiary. To my knowledge, the proposed regs do not mention qualified charitable distributions, but the law continues to have them apply. And then finally, the idea of when our required minimum distributions must begin. It's age 72 generally. It's with reference to 72, more precisely April 1st after the participant reaches the age of 72. There was a little ambiguity that the proposed regs came up with or solved, excuse me, where if you had a spouse whose participant died before Secure and didn't reach age 70 and a half or age 72, even if the spouse is a beneficiary, she now, before Secure Act came out, she can now wait until age 72. So the decedent would have been 72 to start taking required minimum distribution. So that's another taxpayer favorable provision.
Chris, can you give an example on that one?
So my spouse dies in 2018, leaves me her IRA. She was 60 years old when she died. As her spouse at the time, I could have postponed required minimum distributions as a beneficiary until she would have been 70 and a half. Because of Secure Act now, I can postpone until she would have been 72.
Well, even though you're age 80.
Even though I'm age 80. Yep, because I'm a beneficiary. I'm taking as a beneficiary of the spouse.
So you can explain to your children why your second spouse is 40 years younger than you. It's good tax planning.
So this is just more on the terminology here. I think this is just useful for reference. We kind of covered some of the concepts that we'll be using. The 5-year rule is what Alan mentioned, Brandon mentioned earlier. That's the companion to the 10-year rule in essence. What that means is that if you have a non-individual beneficiary of an IRA or a trust that doesn't qualify as what's known as a see-through trust, then all benefits must come out of the IRA by December 31 of the 5th year following the death of the participant. That's another term that would be helpful.
Right. So let me just cover for the laymen who are on this program. If you have an IRA payable to a person, they typically don't have to take anything out until the 10th anniversary date. But now we know that the IRS says you're going to have to take a little bit out every year in the first 10 years. If the person who died with the IRA or pension plan was already taking distributions because they were past the April 1st following their 72nd birthday. Now, if you want to get the same 10-year stretch right, or maybe even a longer stretch right, then you have to have the IRA payable to what we call a see-through trust. Now, this has nothing to do with nudity for those of you in California. This is a trust that kind of is like a person because a person is going to benefit. And there's two types of see-through trust. There's the conduit trust. With the conduit trust, the trust basically says, this trust, as to any IRA distributions, is for mom. And the moment that the distribution comes from the IRA, the trustee gives it to mom. So for that purpose, it's treated like it's mom's IRA. And those are simpler than the accumulation trust, but you have to give mom all the money. And she may misspend it on your sibling that you don't like. So that is the conduit trust. Now, the accumulation trust, guess what? It allows the receipt of the IRA distribution and for the trustee to accumulate that and save it and use it wisely. And in order to qualify as a see-through trust, there are these rules. And one of the most important rules is that as of September 30 of the year following the person's death, everything has to be right. You have to eliminate any creditors who would receive anything during the lifetime of the two primary beneficiaries. You have to eliminate the charities that would receive anything during the lifetime of those two beneficiaries that Chris mentioned under the new regulations. So that's just a little bit of background on the type of trusts that we're talking about. Because when you leave $1 million IRA to your wonderful son or grandson or granddaughter or daughter, they may blow it. So if it goes into a trust for their benefit and they can get the same 10-year or longer withdrawal delay, why not leave it in the trust? And that's the whole that we are talking about here. Now, Brandon, do you want to go through what an eligible designated beneficiary is? Because if it goes to a trust for an eligible designated beneficiary, then it can stretch for longer than 10 years. And then all these rules have a lot more value.
Yeah, and so these are 5 special types of beneficiaries where you can have a longer stretch than just that 10 years. And historically, these have always had to be trusts for the sole benefit of these eligible designated beneficiaries and a conduit trust for these eligible designated beneficiaries, meaning when that trust gets the asset, it goes straight out to the eligible designated beneficiary, with one exception that's included in the statute, and that's for disabled and chronically ill individuals. And the proposed regs made some interesting comments on that treatment, where you might be able to have an accumulation trust for one or more of these eligible designated beneficiaries. We'll go through some examples on that in some slides, but just to touch on who the designated beneficiaries are, is you have a surviving spouse. So if you leave it outright to a spouse, a conduit trust for the spouse, that is clearly going to allow for the distributions to come out over the lifetime of that surviving spouse. If you have a disabled beneficiary or a chronically ill beneficiary, those will allow for lifetime payments over the life expectancy of the beneficiary. If you have a beneficiary that's less than 10 years younger, so they're 8 years younger than me, then that can come out over the lifetime of that beneficiary. Now, the minor children are interesting, where it's not a full lifetime stretch, but you take lifetime equivalent distributions until they reach the age of majority, and then you get 10 years from there to make the full distribution of the IRA. So it's age of majority plus 10 years for those minor children. And we now know clearly that the age of majority is going to be defined as the age of 21 for minor children, regardless of what your state law says the age of majority is. So those assets can remain in trust or remain in the IRA until the minor reaches the age of 31, and then those assets would have to come out. So those are the 5 special beneficiaries. Everyone else, adult children, your niece, your nephew, your grandchildren, those assets are going to have to come out within 10 years following your date of death for those situations.
And as we said before, the measurement of whether you are a disabled beneficiary or a chronically ill individual is a snapshot at the moment of death. So, one of the things we're going to have to start telling clients is, oh, I'm so sorry to hear Grandpa died. Is there anyone disabled or chronically ill that needs to go see a doctor right away so we can document as close to the date of death as possible that's the situation. It's not good enough that it started the next day. So I think it's important, and I think lower income families are going to have harder times because they're going to have less documentation on average because they receive less medical care. So I expect that this definition may change with the final regulations because it is, I think, a little bit discriminatory, but time will tell. Now, Chris, tell us about the importance of that note at the bottom of page 22. This is the most important note at the bottom of any of these pages in the entire presentation.
I would disagree with that last statement, but it's important no less. The least is rapidly rule, if those of us who heard it in the song at the outset of our presentation today, it frankly goes as follows. So if I die after my required beginning date, so after age 72, and I leave my IRA to a trust that's not a see-through trust. It benefits charity, for example. So the 5-year rule would apply. Well, the least as rapidly rule would allow the beneficiaries of the trust to take over my life expectancy, even though I'm dead, and essentially at least as rapidly as I would have had to take out the distributions if I were still living. This is sometimes called the ghost life expectancy rule. It applies only if the participant has started taking required minimum distributions during lifetime and then dies. Back in 2020, there was some concern that the rule would no longer apply, but I think the proposed regs make it clear that the at least as rapidly rule / ghost life expectancy rule will continue to apply.
Which is good for taxpayers, but bad for us because we can't use that song anymore.
It's a great song, though.
I bet wrong on that one. So then, okay, so we talked about that. We talked about the at least as rapidly rule. We even made its own slide because it's so important. So if you're over 72 and you die, the bad news is your 10-year stretch trust still has to get payments for those 10 years. But the good news is you can stretch beyond 10. Are you frozen or thinking?
I'm sorry, we didn't hear you, Alan. It seems that the at least as rapidly rule would continue to apply so that it would come out over the life expectancy of the deceased participant,
Right.
notwithstanding the 10-year rule, but the proposed regs aren't necessarily clear on that point.
Okay. So who's going to lead us through the rest of the discussion here?
Yeah, I'll hop on this first one. I think we've covered this where we've talked about how this 10-year rule might change after the required beginning date. Meaning, if the plan participant's already taking required minimum distributions, then those distributions are going to have to continue in years 1 through 9 based upon the life expectancy of the beneficiary. And then in year 10, everything comes out. Now, if you've died before the required beginning date, meaning you're not taking distributions, then you do get the full 10 years deferral, which is the crazy part of this, is that they've now bifurcated this 10-year rule where you have one 10-year rule that applies if you die before your required beginning date, where you can just defer all distributions for 10 years and then distribute everything in the 10th year. If you're after the required beginning date, then in years 1 through 9, you have these distributions that have to come out with everything coming out in year 10. So we'll see what happens here, but this is the one kind of shocking thing in the proposed regs.
Okay, so on definition of a minor, they did away with the ability to go to age 26 for somebody being educated, or is that gray? Because I was trying to understand what the regulations were saying on that.
Yeah, the definition, my understanding is that it's just a straight 21 years, and there's no exception if you're in school up through age 26. We'll look at that more closely because I have known that other speakers have said that age 26 rule is still in effect, but I haven't seen that myself in the regulations.
So that's what we call a WFN, which stands for Wait for Natalie. So then what about the definition of disabled here?
Yeah, so this is another tricky one where they've made it just a little bit more complicated in that there's really three different definitions that can apply. If you're under the age of 18, you can see there that the individual has to have a medically determinable physical or mental impairment that marks severe functional limitations that can be expected to continue for a long or indefinite duration or expected to result in death. If you're over the age of 18, then there's a little different definition that applies in that you're not able to engage in any substantially gainful activity, again, for a long continued indefinite duration. And then there's a third definition here is if you're considered disabled by Social Security, that's a safe harbor. You're going to be disabled for purposes of these RMD rules. So three different tests there for disabled.
And the definition.
Go ahead, Alan.
Yeah, the definition of disability under the Social Security standard is really difficult. You'd have to be unable to be a greeter at Walmart, basically. So it's really hard to get Social Security disability. Not that I've tried, but I've just heard that. Okay, so what about chronically ill? And this is really, really important because of special needs trusts and how and when special needs trusts can qualify for the stretch, right?
Right. So chronically ill, they've provided a nice definition here in the proposed regulations where it's essentially you have to be unable to perform at least two of the activities of daily living for a definite period of time, all based upon certifications from a licensed healthcare practitioner. So those daily activities, you have them listed here at the bottom: eating, toileting, transferring, bathing, dressing, and continence. So if you're unable to perform two of those, then you're considered to be chronically ill. There's other aspects of this definition as well that you have here on slide 27. I won't read through those, but we have that definition here as well.
Okay, so Chris, do you want to go through the pyramid?
Yeah, and I'll just go through really briefly here. This pyramid is what we prepared back in 2020 when we were understanding the Secure Act. And as far as we can tell and say with degrees of certainty, the rules here generally stay the same. Now, Brandon and I will talk a little bit later about a possible expansion of some of the rules here that aren't necessarily clear under the proposed regs. But just going through it briefly, Tier 1, if you have outright to a surviving spouse, the surviving spouse can roll over the IRA or retirement plan into his or her own retirement plan and take life expectancy rule. That has not changed from the Secure Act or the proposed regs. The next tier is the life expectancy rule, and this is if benefits are payable outright to or into a conduit trust for any one of those 5 eligible designated beneficiaries: surviving spouse, minor child, surviving spouse, disabled or chronically ill individual not more than 10 years younger than the plan participant. And we call this the more favored because it goes really throughout the life expectancy of any one of those, actually 4 beneficiaries. We separated the minor child into Tier 3. And the reason for that is a conduit trust for the minor child or an IRA payable directly to a minor child only gets the stretch up until the child reaches the age of majority. And at that point, the 10-year rule kicks in which place you basically get a majority plus 10 for a minor child. Tier 4, this is the 10-year rule as we understood it, where assets are left in an accumulation trust for any one of the above, except for a disabled or chronically ill beneficiary, a conduit trust for anyone who's not an eligible designated beneficiary, or outright to anyone who's not an eligible designated beneficiary. As I mentioned, there may be some expansion of this 10-year rule where an accumulation trust could possibly qualify for a limited stretch, and we'll talk about that in a little bit here. But as of right now, it's certain that the 10-year rule, at least the 10-year rule, will apply for an accumulation trust under most circumstances. And then finally, the aforementioned 5-year rule, where if you leave it to a charity directly or a non-individual or a trust that benefits a charity or a non-individual, all assets have to come out of the retirement plan within 5 years December 31 of the 5th year following death. I don't think it's disputed, gentlemen, that you can wait until the end of the 5th year to take out the benefits, which is why so many of us are kind of shocked by this interpretation of the 10-year rule, because the statute has always said, take the 5-year rule and just substitute 10 for it when applying the 10-year rule. And the proposed regulations now, of course, during the 10-year rule require that we take distributions in years 1 through 9, whereas the 5-year rule, no such requirement exists.
Well, that's interesting. And that's when the participant is over age 72 when they die.
So the 5-year rule would apply at any event. If I died tomorrow, under 72, and I leave my IRA to a trust that benefits charity in part, and the charity is not eliminated by that September 30 designation date, then the 5-year rule would apply.
Okay, let's go over some questions that may help reinforce what we've discussed. The first question is, does this apply to Roth IRAs as well, or how would these rules apply to Roth IRAs?
Brandon, I'm a little fuzzy on this.
Yeah, I think the same rules would still apply, that the minimum distributions still have to come out of the Roth within the 10 years that the 10-year rule would apply. There may or may not be taxable, but I think you still have to pull assets out of that Roth if as an inherited IRA.
Here's another one. Can you use the 10-year rule if the person died in 2019 and the beneficiary is not a spouse?
Well, I think at that point you would be entitled to the stretch, assuming you qualify otherwise. But keep in mind, what we're talking about is the minimum. Nothing prevents a beneficiary, if they're allowed to under the terms of the trust or under the terms of the plan, if they can pull everything out in 1 year or over 10 years, they can do that. What we're doing is setting the minimum baseline for when distributions must occur. So the short answer to that question is yes.
And Laura wants to know, when will the proposed law become real law? Some people are saying it'll happen before the end of this year. If that's possible, that's probably a good estimate, probably sometime December, January, or February.
Well, the 90-day period for comments on the proposed regs ends at the end of May. So I would anticipate, obviously, there'll be a boatload of comments coming in. And then however long the IRS takes to review, implement, or disregard those comments, I think maybe you're right, Alan. By the end of the year, sounds like a reasonable expectation.
And then Jonathan Gassman says, it sounds like under the 10-year rule, basically, you can't wait until the 10th year to take out all the money. You have to take it out a little year. Is that what I understand? Yes, John, if you got here late, if the plan participant who died was in pay status because it was past April 1st of the April 1st following their birthday, then these new regulations say even if you have a 10-year stretch, you've got to take their annual minimum distribution during those 10 years, whether you like it or not. So, and that's looking forward to seeing what Natalie says about that on Thursday. So Chris, these slides, tier 1, these are just bigger blow-ups of the same
Just
slides.
zooming in, yep, on the applicable tier, so we can skip through the end of the pyramid, which
Okay.
hopefully we'll be able to update soon once we continue to peel back this onion that are these proposed regulations.
In our ample spare time, yes.
So Alan, here's another taxpayer favorable thing. There was some question as to when does Secure apply for individuals who inherited IRAs before 2020. So example, my grandfather leaves me an IRA, he dies in 2018. I continue to take distributions over my life expectancy based upon the law as it existed in 2018, the pre-Secure Act law. Well, when do my beneficiaries, what do my beneficiaries have to deal with? Is it Secure Act? Is it pre-Secure? And the regs make it clear that if I died before this January 1, 2020, when Secure came into effect, then the old law would continue to apply for my beneficiaries, right? So I'm the designated beneficiary. I died before Secure Act. My kids inherit my share. They can continue to take over my life expectancy if I died before Secure. But if I die after Secure, if I died in 2021, then the Secure Act would apply, meaning that on my death, my children would have to take out subject to the 10-year rule. So I supposedly, it seems like thinking out loud here, if my grandfather was over 72 when he died, or 70 and a half when he died, then it seems like my beneficiaries would have to take distributions for years 1 through 9, as they would have continually, and then in year 10 everything would have to come out. Right? That's what we think to be the case based upon our review of the regs.
So it really comes down to, if you have a life expectancy of longer than 10 years, you would be more favorable in a pre-secure world where you could continue taking out of the life expectancy. But if your life expectancy was under 10 years, then it probably doesn't make much of a difference, because it's still taking out over your remaining life expectancy. So it'd come out over that term. If that's less than 10 years, then it would be the same pre and post secure.
Right.
What else do we want to cover? We're at 37 minutes.
Alan, I think the next slide has just a wrinkle here to the rule we just discussed. This involves a situation where you have a trust that has more than one designated beneficiaries. And here's an example. Our good friend Alan has passed away in 2018. He sets up an accumulation trust, benefits Brandon and I. If I'm the older of Brandon and I, then my life expectancy governs on the distributions. If I died before January 1, 2020, then Brandon can continue to take distributions over the course of my life expectancy. If I die after secure, then the 10-year rule applies, and Brandon has to pull all assets out by December 31 of the 10th year following my death. So there was a little bit of lack of clarity when the statute came out, and the regs give us a little bit of guidance.
Very good. So we need to go back through the trust that we're handling for clients who died before the Secure Act and see if things need to change now. Very interesting times indeed.
Yes, it is. All right, so Brandon, maybe you and I can kind of dive into this whole issue of determining beneficiaries. And this is kind of a really confusing topic. The regs didn't make it a whole lot clearer. I was telling Brandon this morning, the preamble can be helpful. You read the preamble, and sometimes the preamble is confusing, and then you go to the regs, and the regs are actually easier to understand. But nevertheless, there are a few points that are worth mentioning. So the proposed regs give us rules on whose lives are we going to look at for required minimum distribution purposes. One of the great things by the new regs is beneficiaries who fall into these categories can be disregarded if certain events occur by that magical September 30 after the calendar year of the plan participant's death. So simply, if you have a beneficiary who's predeceased the plan participant, that beneficiary is not taken into account. If you have a simultaneous death with a beneficiary and the plan participant under state law, or if the beneficiary executes a qualified disclaimer that's both valid under federal tax law and also applicable state law, the disclaiming beneficiary's life is not taken into account. If the beneficiary is paid out so that their interest is completely satisfied before that September 30 day, they're disregarded. Here's the situation. My trust leaves it to my good friend Brandon, and it also says pay $100,000 to my favorite charity. Well, if my favorite charity is paid out by September 30 of the year after my death, they're not taken into account, which can be very helpful. And then finally, if a power of appointment is exercised before that September 30 day, then the other permissible appointees who didn't get it by the exercise or can no longer get it if it's restricted are disregarded. So more pro-taxpayer guidance regarding required minimum distributions. Brandon, second tier beneficiaries.
Yeah, this is we talked about this, where you can disregard that almost death after the second tier beneficiary. So I won't readdress that, but I think what's interesting here is the example where they have here an accumulation trust that's payable to the spouse, and then upon the spouse's death, it goes to the brother. The brother survives, then it goes, or if the brother predeceases, then it goes to a charity. Well, it says clearly you can disregard a charity. But the interesting aspect of this is it actually talks about the trust being able to be accumulated for the spouse who's an eligible designated beneficiary, and then being able to be paid over the life expectancy of that spouse, which is a new concept that we weren't aware of and didn't think that the laws allowed. So the example could just simply be wrong, or we could have this new ability to have accumulation trust for eligible designated beneficiaries. And then here's another interesting example where you can also disregard someone if their death is conditioned on basically a minor predeceasing. So off chance that a minor dies, before their life expectancy, you can disregard the remainder beneficiaries after that minor. So again, they give the example of accumulation trust is the beneficiary. You have a niece that is the sole beneficiary of this trust. If the niece predeceases, then it goes to the employee's sibling. So do we have a eligible designated beneficiary of this trust, or do we have to consider the remainder beneficiaries, which would not allow the lifetime stretch, or a minor child to be eligible to take those longer stretch distributions? Well, the example in the preamble says because it's conditioned on the death of an individual who has not reached the age majority, we can disregard the sibling as a beneficiary, and therefore the minor is the only beneficiary of this trust, and we can qualify for the majority plus 10-year stretch rule. So interesting examples there. I think this is an important drafting note that this has to be distributed outright to the minor by the end of that 10th year. If it's not, so for example, if you say it's distributed outright at 35, now those remainder beneficiaries have to be taken into account. You would not have an eligible designated beneficiary of the trust because of that niece or sibling being a beneficiary, and you would have just the 10-year rule that would apply. So I know a common age in a lot of our documents and others is everything goes out right at the age of 35. We might want to consider redrafting that to be 30 or 31, so we fall under this exception and don't have to count those remainder beneficiaries.
We'll keep it at 35, but let the trust protector have the ability to move it to 31.
Mm-hmm.
See if it's even worthwhile moving it.
Right.
But for the record, though, the vast majority of our state plans say that it stays in trust forever.
Yeah.
For the entire lifetime of that child. We don't release it at 35 unless the client makes us.
Yep. All right. I'll skip over that one. Powers of appointment, I think we've covered on the exercise, non-exercise of those. Reformations and decantings, I think we've touched on those. Here are two more interesting rules on life expectancy payouts. Basically, what this is saying is if you have a accumulation trust that's for the benefit of a disabled or chronically ill beneficiary, they're the only ones that can benefit during their lifetime. We can disregard the remainder beneficiaries and stretch that over the life of the chronically ill or disabled beneficiary. The new one that was added by the proposed regs is this concept of if you have a minor child as the beneficiary of an accumulation trust. What this is saying is that if that minor is there and there's other eligible designated beneficiaries, then you can have majority plus 10 stretch. Even if you leave it for a surviving spouse and a minor child, then you have a year plus 10 stretch rather than just the 10-year rule. If you have a adult child and a spouse, then you would have just the 10-year rule that would apply. So there's an exception here for minors, which almost allows for an accumulation trust to apply for a surviving spouse, at least for a period of time. Maybe not for the full life expectancy, but at least for until that minor, would reach age of 31. So Chris, any other comments on those? I know we've went through these regs and examples several times in our heads and still trying to figure them out.
It's like a hybrid conduit accumulation trust, which by definition is not a conduit trust. I'm interested to see what Natalie says on this next week. Maybe there's just a couple of words here that need to be revised, but it certainly seems like there's an exception that wasn't contemplated by the statute to the taxpayer's favor now. We'll see how this is interpreted.
Yeah, and this is the example here directly from the preamble that talks about this trust being the surviving spouse and an adult child. 10-year rule applies. If you have a minor child, then the majority plus 10 would apply. And the other interesting exception here is when, and this is one that we think the example may just be incorrect, potentially, you have someone that is not more than 10 years younger, and you have a surviving spouse as the beneficiaries of an accumulation trust. Well, they say in this situation, because the only beneficiaries are eligible designated beneficiaries, that you can have the accumulation trust apply for the lifetime of the surviving spouse. And I think this is because the sole beneficiaries of this trust are eligible designated beneficiaries, because it's to the spouse, and then if the spouse survives, it's outright to an individual that's not less than 10 years younger. So that might be where we're looking at, if you have a trust that can only benefit eligible designated beneficiaries, no other beneficiary can benefit, you can still have that stretched lifetime treatment. Whereas if you have potential remainder beneficiaries that can't be disregarded, that are non-eligible beneficiaries, we're back into that 10-year rule.
Hey, any final words?
Yeah, I mean, it's certainly, Alan, we're sifting through the rubble when this explosive proposed regulations were dropped last week. And as when they first came out, we figured, oh, wow, maybe this is going to be easy. What they'll show us what changed. But they restated the entire regulations regarding required minimum distribution. So as you mentioned, we're looking forward to Natalie's talk next week. We'll continue to read these regulations, especially when we can't fall asleep at nighttime. And maybe we'll find new insights, new perspectives on this. But largely, it seems that most of the provisions are taxpayer friendly, but for that 10-year rule interpretation that we talked about, who knows what'll happen? These are proposed regulations. Hopefully, that detrimental provision will not see the light of day as final.
Right. Okay, I did want to mention, by the way, if you attended this webinar, you'll be receiving a webinar notice in 3 or 4 hours, and you can watch it as many times as you like and send it to everyone you like and anyone you dislike. We'll also be posting it to our YouTube channel. So if you Google Gassman YouTube, you'll find our YouTube channel, and I think it'll be the featured webinar at the top left of the YouTube channel. So I wanted to also mention what the Teapot Trust is, and if you Google Gassman YouTube Teapot Trust, you'll see the silly video that we're about to show you. But the way it works is, if you have, say, $1 million IRA, Grandpa left, it goes into one 10-year pot trust, and then the trustee can decide who to distribute it to during those 10 years. So he can give more to the lower income grandchildren and children and less to the higher income people. At the same time, leave another $1 million into a separate 10-year pot trust. So when the trustee is giving money to the school teacher daughter or the charitable son who doesn't work except for charity, they can also dribble out the non-IRA money to the neurosurgeon and the actuary. So just to balance things out, at the end of the day, you save a lot of income tax doing that, and you keep the family together for 10 years, and you have a little bit more professional surveillance and impact on the children when they meet and talk about this $2 million in pot trusts. So Kelsey, are we ready to show the Teapot story? And Ken, Chris, and Brandon, thank you so much for all your efforts. It was not an easy week here to put all this together. Thanks for letting me take 1/3 of the credit when I spent 10% of the time, but I'll be reading everything this weekend to improve it. And I'm sure we do have 90 minutes of material easily when it's time to go to the next level. So send us your questions, comments, and suggestions. You have our email addresses here. Thank you so much for attending, and enjoy this musical video. And thank you to Kristen Sweeney for helping to write it and perform it while being a fantastic mother. And hopefully it'll be here in a minute.
Are you ready, Eliza? Here comes our special song. Grandpa needs a teapot for his trust. Talk
to his attorney, 'cause Grandma said he must. The lawyer got him fixed up right as rain. Now his IRA payments won't go down the drain. The Teapot is a special kind of trust, it's true. Here's an example of what it can do. Save you time and money, and don't forget to mention it's the perfect plan for Grandpa and his pension. Do you know what a pension is, Eliza? We could talk for hours about its many perks, but now you might be wondering just how the Teapot works. Well, picture 3 cups filled with liquids alike, but rocks in 1 cup means the liquid takes a hike. So although the cup looks full, it's really not. There is an important lesson to be taught. The Teapot can be used to avoid this drought, so the IRS won't pour you out. Yay! Good job, you! Yay!
Thank you for attending this mediocre presentation. Chris, you did a great job. Was there anything else you wanted to mention?
No, Alan, have a wonderful day. I forgot your name, Mr. Needlewick, I believe.
Yeah, Mr.
Pleasure to make your acquaintance. Enjoy the rest of your weekend.
Enjoy your soccer games today, Chris. Try to bill some hours too, though, if you have time.